Okay. First of all, I want to welcome everybody. Brian Horlick. I'm a condominium lawyer. I want to thank everybody for coming and to visit us today at our weekly live stream. So let me just say a few things as we're starting. Why are we doing this? Well, we are hosting a live stream AMA, Ask Me Anything, session every Wednesday at 12 noon. We're doing that so that everybody in the condominium industry who wants to can feel free to connect and to ask questions of things that are happening in the condominium industry. We are in a very social business. We deal with boards of directors, owners, property managers, trades on a daily basis, and here we are in the COVID era, and we are not able to deal with anybody on a personal basis other than when things are of an essential nature. So we hope that we are providing value to everybody and a forum where people can come together even though it's on a remote basis. I'd like to give a shout out before we start to our frontline doctors, nurses, personal assistants in our hospitals and long-term care facilities. I'd like to give a special shout out to Dr. Sarah. And Sarah is the wife of one of our star condominium lawyers, Bradley Chaplik. And Sarah works for a number of long-term care facilities specializing in senior citizens. And that is a risky proposition today. So good for you and keep up the great work, Sarah. We also want to give a shout out to Ellis Michael Duggan, who I think now is 4 days old. So that's Tim Duggan's new son. So we welcome him to the world, and hopefully the world will be getting better shortly. I want to say that we also have some fan mail. Yes, we are getting fan mail. And I'm going to just read this if I could. Again, we're not alone. We're all together. We're all in this together. Good afternoon, Brian. We appreciate and value the information and reiteration of material you have been providing the condo community during this COVID-19 pandemic. It may sound silly, but receiving your newsletters and webinars provides added support to us all by not feeling isolated and alone. Being frontline essential service puts a strain on everyone day in and day out. The term "we are all in this together" could not be a truer statement. So here are my humble thanks and encouragement to continue in good health. So this is from a condominium management provider, and we thank you for your fan mail. As you know, we are moving forward every Wednesday at 12 noon with the live stream AMA, Ask Me Anything. You can ask us anything condo related. Doesn't have to only be COVID-19 related. That's Wednesday at 12 noon. And we also are sending out every Monday evening an updated frequently asked questions dealing specifically with COVID-19 issues. And if you haven't received yours, please drop us an email. We'll put you on our list. Now we have a number of questions, and I'm going to encourage everybody who wants to ask a question to type it in. I'm going to read the questions and then we can discuss the answers. There's also a subscribe button on your screen, and if you could please press that, you'd be subscribing to our channel, and we'll be able to email you with further information. So let's start the questions. From Dorina: do residents and their visiting family members that are not in quarantine have access to the grounds, in brackets, walking around the building? Well, I'm going to say to you this, that one of the emergency orders that the province of Ontario put out was that there was to be no congregating in public and or private areas outside in certain facilities, whether they're parks, places where people would sit and congregate. And so therefore, I'm going to say to you that residents and family members should not be congregating in the common areas of the building, inside or outside. If they want to take a walk, it should be outside, not in these areas. Dorina has a further question. Do you have any policies for visitors to residents? Are they allowed? Good question, Dorina. The orders of the provincial government set out that you should not have more than 5 people congregating together outside of a single family. For visitors, I think it would be too much to ask and too much to monitor to say that there should be no visitors at all to the condominiums, especially when you have certain people, visitors, let's call them that are really giving assistance to elderly people or to people that might not be well, bringing in groceries, assisting them with their everyday living. So it would be excessive to ban all visitors. I do know that there are some condo corporations that have banned visitors. I'm not in favor of that. But then again, I think it's an important consideration to see who exactly or how your community is made up of, what age are your residents. So if you are in a condominium corporation in a building of, let's say, majority senior citizens, and we know that at a certain age, the COVID issue is much more deadly, shall I say, perhaps it would make sense in the adult lifestyle setting to severely restrict visitors, perhaps to caregivers and those that are essential to assisting the residents of the building. But in the normal course, I would say visitors should be allowed, but owners and residents must be reminded or educated to the fact that given the COVID-19 situation, visitors and people who are not really from the building should really not be coming in excessive groups. Further question, Bruna, Condo Corp 2146. Bruna, how are you? Doing a great job there at the Avenue, I hear. Is the opening of the irrigation system an essential service? Example, if irrigation does not open in the next little while, it may lead to other issues. Thank you. Well, in my view, the irrigation system is not going to be essential. It's not definitely going to be necessary to maintain safety, security, and sanitation. Although I can assume that in some people's minds, having a beautiful bed of roses is essential, but I don't agree. So I'll tell you what, no irrigation system. If you want to, save your flowers, maybe, a bucket of water might help. But no, the irrigation system to me is not going to be essential. We are in a very difficult, things are not that important. So thank you very much. Now we have the noted professor himself giving us his comments, Murray Johnson. And Murray says that he does not believe irrigation is essential. And Mr. Johnson, I am going to agree with you. Next question. Jean Lewis, Duca Property Management. Jean, how are you doing? Brian, can you discuss how to handle a turnover meeting in today's environment? I certainly can, Jean. So as you know, new building, when the new building goes up, there's a board, and the board is what's called the first board, which is the declarant appointed board, meaning the builder. So the builder has his own nominees, or his or her own nominees on the board. The declarant is obligated to hold a turnover meeting after the majority of the units are sold. And the turnover meeting, at that point in time, a new board is elected. So really the big question here is, how do you have a turnover meeting where a new board can become elected and other important business can be attended to, which is set out in the Condo Act? How do you do that if you're not really supposed to have meetings of more than 5 people, and you need to have, people voting, you need a quorum, which is 25% of the owners of the building. You need to, have certain votes to get the new board on, etc. So the answer is very simple. What you should do, what the declarant should do, is while the declarant is in control of the board, and before the declarant has sold the majority of units, at that point in time, the declarant has control of the condominium corporation. And it will be easy for the declarant to pass a bylaw allowing for electronic voting. And it would be easy for the declarant at that time to pass a bylaw allowing for meetings to be held electronically, virtual meetings. So if the declarant does that, which again is simple to do because the declarant is in control of all of the votes. Once that is done, it will be much easier in this climate to move forward with a virtual meeting with electronic voting in addition to your regular proxy voting. So that's, to me, the very best thing to do. And that's a good question, Gene. Thanks very much. Until next year. Due to COVID-19, should the condo give back the special assessment collected, and are the owners responsible to still pay? I guess this is, there's a lot in that question. So let's talk about special assessments. If you're going to levy a special assessment, obviously as a condo corporation, it says that you need money. If the special assessment is collected and the project does not go forward, then you have the money, but you haven't done the project. But it says here in the question, if the project is postponed until next year, I don't think you need to give the money back. I think that, if you have the money, you keep the money and you use it for the project for which it was intended. But if you're not going to be doing the project, then why would you really want to, be collecting the funds? The project, this takes us to another issue as to whether the project is essential or not. And if it's not essential, you're not going to do that project now. So, if you've collected the money, you should keep the money. Whether, there's light at the end of the tunnel or not, COVID will be over and done with one day. And here is from Daniel Kligerman. Daniel, if big budget reserve projects are delayed due to COVID, should we consider reducing reserve fund contributions from owners to give them financial relief, and because the funds won't be spent as expected? Well, it's a good question. We have, the issue of the reserve fund has come up a number of times already in respect to, whether we should be, collecting the amount set out in the fund or in the plan. And if we do, are we able to use some of the money from our reserve fund to, assist unit owners in this time of financial distress? So number one, you cannot use the reserve fund money for anything other than major repairs and replacements of your common elements and your assets. So that is for sure, you cannot use the money to defray anything else. There are ways in which you can change your funding plan. So if you feel that you're not going to be moving forward with certain types of repairs and replacements, as far as relief of fees and expenses are concerned, it is important to look at financial hardship on a case-by-case basis. It's not appropriate to take a blanket position and say, okay, because of the COVID issues, we are reducing our maintenance fees, or we are going to waive the fees, or we're going to, not charge them now. There are people who can pay their maintenance fees and will pay their maintenance fees right now. There are others that may need some assistance. And so the condo corporation, of course, needs to pay its ongoing expenditures, only gets its money really from the collection of maintenance fees. And therefore, to have a blanket policy of reduction is not good, because you are assisting people who don't need the assistance, and at the same time reducing the amount of money you have to pay your bills. So next question from Olexil. How can one subscribe for the HLD newsletter? I'm sure there is tons of great information. Well, thanks very much for your comment. What you can do is drop us an email. We are happy to put you on the list. As I said at the beginning, we have a HLD frequently asked questions, which we actually update sometimes 3 times a week. And we do that because every time things change, and I will tell you that the provincial government orders are changing all the time, and the issues surrounding those orders are changing all the time. And so as they change, we consolidate and update our frequently asked question newsletter. So you will see some of the same things on it as you did prior, because nothing has changed for those things on the frequently asked questions, but you are going to see the most up-to-date information there. So if you want to be on the list, just send us a note. We're happy to send them out. A lot of people look forward to them on Monday nights. We used to watch football, Monday Night Football. Now we wait for Brian Horlick's frequently asked questions. You see how life has changed. I would prefer to watch football. Next, Miriam Jalali, how are you? Brian, and thank you for the great job. You're very welcome, Miriam. Question is, should corporations send letters to residents in regards to oil on the parking spots now, with COVID-19 going on and residents are staying at home? Well, interesting question. The thing is this. We are living in a very odd place in life where, we have this really killer of a disease, of a virus, and it will kill you. It will. And at the same time, we need to try to carry on life. And COVID-19 is getting in the way of carrying on life. But we need, as a group, to move forward as best as we can with life and not let this nasty COVID virus take us over. So I would say yes. I would still write compliance letters. I would maybe tone them down so they're maybe a little bit more friendly, but I would definitely write the letters. The fact that we're in this terrible situation doesn't alleviate people from complying with the basic rules of co-ownership, which is what condo is. So yes, I would write those letters. Now we have the illustrious Ron Britt. Ron, how are you? And thanks for joining. Question from Ron. In regards to garage cleaning, window cleaning, and any other outside work, although not deemed essential, can we still carry on with these projects? And the answer is you cannot. And you cannot because they're not essential. And unless you want to have a problem with the government of Ontario coming over to your condominium property and potentially bringing forward some type of fine or penalty, I'm not going to suggest that you engage in non-essential services. To say that you could engage in non-essential services would almost be like having the restaurant at the corner open up because they want to, and they can't because they're not essential. Now, then again, if you wanted your lawyer to do your windows, being a lawyer is an essential service, Ron, so maybe we could help you out at an appropriate hourly rate that we could negotiate. Next, Ron Britt, if the trades are willing and practice safe distancing, after all, they will more than likely not come in close contact with anyone. Again, I'm not going to change my opinion, although I know you want me to. Now we have here probably the illustrious Mr. Chaplik or Mr. Kapoor from our office have set out in the chat the link to get our most up-to-date Horlick, Levitt, Lella frequently asked questions for COVID. So you see the link there, and you will be able to click that and you can get it. Roz Dean, if an AGM was postponed due to COVID-19, is it necessary to resend the pre-AGM package? Is it required to send an entire new AGM package or only the changes? Good question. Your original meeting was postponed. I will say that you should probably resend all of your information. You should send out a new preliminary notice of meeting. You should send out a new AGM package. My real question to you, Roz, is how are you going to conduct your AGM? And for those people that are active in the condominium industry, you will know that CAO recently put something on their website, which basically suggested that given the fact that people are not meeting in groups greater than 5, in order to move ahead with potential owners' meetings, they suggested that it was possible for an electronic voting bylaw to be passed, and they further suggested another bylaw which would allow virtual meetings as a manner in which owner meetings could take place. So this is what was set out by the CAO, the Condominium Authority of Ontario. This led to a rush of phone calls to our office and others, basically saying, well, let's do that. However, if you read carefully the CAO memo, the CAO post, it said that their first position was that you should adjourn, you should postpone your AGMs. And then it went on to say, however, if there were special situations that you needed to have of the meeting, then there would be potential ways to do that. So my advice on AGMs, for AGMs, my advice is do not move forward with your AGMs yet. Let's wait to see when this virus situation is going to work itself out. When will we be able to have meetings? And I'm talking about AGMs, and I'm saying specifically AGMs because in the legislation there is a provision specifically set out that owners can ask any question, any relevant question at the AGM. That's a statutory right of an owner. Similarly, owners have the right to ask questions of the auditor, another statutory right of an owner. And it's very difficult to do these things unless you're at the meeting. So I will say this, as far as moving forward with special meetings, not AGMs, meetings such as we don't have quorum, we lost quorum, meetings such as we need a bylaw for a certain type of thing. For specific special meetings, yes, I would agree that you can go forward with those meetings, but for AGMs, I would suggest no, you postpone them until better days. So I'm going to just say this. It is disappointing, and I'm going to shout out now to Doug Ford. Doug Ford, if you can hear me, I will tell you on behalf of myself and all of the condominium industry that we need to be heard as the condominium industry, as well as everybody else. And you need to put us on to a special order or amend the special order, which you have in place for business corporations. There's a special order for business corporations that basically says those business corporations must call and hold their AGM within 90 days after the emergency order is over. And it also gives those business corporations the right, without a bylaw, for electronic voting and virtual meetings. So what I'm saying to you, Doug Ford, and I know you're busy doing some other things, but for us poor condo folk, we would really like to have the ability for electronic voting and virtual meetings during the COVID period. And we don't want to go through the headache and the hassle of having to pass bylaw. So if you could do an order for us, a special order, or amend the order that you have for business corporations, for us poor condo folk, we'd really like that. So Doug, if you're listening, and I'm sure you are, please attend to that. Thank you. Next, we have here, to follow Ron's question on window cleaning, my window cleaning company said they have been able to work so far. Should I cancel our window cleaning? Well, I think if you're going to ask any non-essential service provider if they're able to come, their answer is probably going to be a resounding yes, especially if they work outside. But I'm not recommending that they should come. It's not essential. Now we have here, Gene Lewis is back again, asking a very nifty little question. And his question basically revolves around social gatherings. Limiting 5 people in a group. Gene says, I understood this applied to social gatherings, but did not apply to businesses. Can I hold a board meeting with proper social distance with, say, 6 people? So the point is this: you cannot have more than 5 people in a social meeting or a business meeting. The interpretation of that has been that would include, for example, going to church, going to the mosque, going to synagogue, and even though those are not social gatherings and those are not business meetings, I think you're skating on thin ice if you're going to make that distinction. And I'm going to say that I would be confident that you would be getting a ticket from the bylaw enforcement people if you had meetings of more than 5 people and said, well, hey, it's not a social gathering, we can do it. So I'm going to suggest no. Next, Murray Johnson, the professor. If an AGM has been rescheduled to a future date, you have to have ESP. So that would be ESP. I guess, what is that? Is that another virus that's out there? Why not wait until we all get the green light and are over the pandemic? Well, Mr. Johnson, I agree with you 100%. There's no point to put forward a new date for your AGM. We don't know when that new date is going to be. We should all just cool our jets, take it easy, take a breath, look at the big picture. I think we should wait and see what happens by September. If things are open for business in September, then we should start planning and holding our AGMs. There's really nothing that is going to be so detrimental in life that we can't wait till September. Now we have here, from Oleksiy Kosovsky. Natalia says, I will sign that petition to Doug Ford. Okay, I'm with you, sister. Ramesh, can you please throw light on what is the legal requirement if we need to change one of the amenity rooms into a management office? Can you please throw light on that? Oh, the legal requirements. Okay, so what you're saying here, is you want to make a change in an asset, and the change of an asset is governed by Section 97 of the Condominium Act, and you can absolutely do that. The question is whether you have to give notice to owners or not, and the answer to that is based on the cost of the project. So if you look at the cost of your project and you look at what percentage that is of your budgeted common expenses, if it's below the certain threshold, then you'll be able to do it without notice to owners. So that would be a change under Section 97. Bruna, we have our in-suite heat pump maintenance schedule in the next 2 weeks or so. So again, you have to look at whether these things are essential services or not. And if they're essential services, you will want to go forward with them. Of course, if they're essential services that you need to have unit owner access, owners may not be very pleased with that, and you may want to rethink or whether or not now would be the time to do that. Now, another question here from Mr. Johnson. Mr. Johnson, I'm going to have to charge you because this is your third question, so we'll be billing you for this one. When the amenities are closed, why not just use it as a second office during the closure? Johnson, you're a smart guy. I agree with Murray. Very smart. Another question from Bruna. If the maintenance is not performed and something goes wrong with the heat pump, will the corporation be held liable? In case of damage and a possible claim, will the insurance company penalize us? I think that, you'd have to look at the facts of the case. Obviously, I think that given the circumstances, the unique situation that everybody is under, I think that any type of, penalty will have to be looked at in view of that. And I can't see how, anybody would be able to take a position that the corporation was negligent in the fact that they were trying to, use social distancing and social policies to stop the spread of a virus that can absolutely go into your building and start killing your residents. Nita, hi Brian, can the replacement of the hardwood flooring after water damages be considered essential? Thank you. So I think I'm going to go and kill myself now. Look, it's essential only to the person who doesn't have the floor, but it's not essential in the big scheme of things. Again, is it strictly necessary to manage and maintain safety, security, and sanitation? I don't think so. Is it a nice thing to have a floor? Yes, I think so, but I don't see it as essential. Now, here we have Harmony. Is the DHW tank inspection essential? I was going to have that done before COVID. Should I proceed? Again, what has to govern your decision-making process is it strictly necessary to manage and maintain safety and sanitation? If it's not necessary, strictly necessary, I would put it off. Ryan Stone, presently gardening is a non-essential service. However, landscaping is different, such as landscaping is different, such as grass cutting and trimming, etc. Again, we're going back to what we need as essential as opposed to what we want, and it's great to have beautiful flower beds, and it's great to have manicured lawns. But in 2020, where we are in life today, it really doesn't seem to be very essential. All right. So I'm going to just say a few other things here. We have run out of questions. If you have more questions, shoot them through. I'm going to look at our COVID-19 frequently asked questions, and we're going to discuss some of them. So I want to say this. In our FAQ, we have set out that managers should not be attending the management office and they should be working off-site. And we say that with respect to work that is non-essential. So non-essential work is things that you could be doing from your home office on the phone or on your computer. There is, however, of course, essential work that the condominium manager must do, such as attending to any type of emergencies, any type of physical site visits, etc. And for those things, the manager, of course, has to be on site. So I think it's a combination of using common sense. I don't think the condominium managers should be there every day. They're not mandated to be there unless the service is essential. And again, we know what that is. So for those essential items, the manager would definitely or should be on site. But otherwise, we have to practice appropriate social distancing. But for all of those people that are here today listening, I think it's important that we all understand that just because the manager is not working in the office and is working at off-site, there's a lot of work that needs to be done to manage your condominium corporation that is office work, and that office work can be done on-site or off-site. And because of the pandemic, it's being done off-site. So don't think your manager is at home sleeping, although they do sleep from time to time. So here we have a few things of note. The government came out with a new program for condominium for employers, and that includes condominium corporations. So if you have a condominium corporation and you employ staff, you will be able to take advantage of what's called the temporary wage subsidy, and that is a 10% wage subsidy from the employees that you have. It lasts for 3 months from March 18th to June the 19th, and it equals to a maximum of $1,375 per employee and a maximum of $25,000 per employer, which would be about up to 18 employees. So you're entitled to a 10% wage subsidy for 3 months, and I suggest all condo corporations take advantage of that because everybody's in the same financial crisis together. So that's very important. Another important thing is a question has come up for some people. We have lost quorum. Our board has lost quorum. What should we do? Now, for losing quorum, would be it's an important meeting and a special meeting because your condo corporation cannot move forward with its business without having a quorum on the board. So that's really key. So this is a situation where I would say, yes, move forward with either a paper meeting. In other words, only have proxies submitted. You could appoint, let's say 3 or 4 people to collect all the proxies. Everybody would give their proxies to either 3 or 4 people who could actually have a social distance meeting in person so that you would be able to elect your further directors so that you could alleviate the lack of quorum. And again, if you had electronic voting, that would be of assistance too, and perhaps a virtual meeting as well. Everybody knows for short-term rentals that the government mandated in one of their orders, no more short-term rentals effective April the 5th, unless it's for housing. So in other words, if you're coming in to spread the wealth or the germs and you're a tourist, the answer is no, you can't come in. Now we have a few more questions here. Very good questions here. All right. All right. Here's a very good question, and it's related to force majeure. So first of all, let's talk about force majeure. What is that? Force majeure is a contractual term. It's a term in a contract. Okay, if it's not in a contract, if it's not specifically set out in a contract, it's not in the contract. So force majeure is a term in a contract that deals with what happens if a party cannot honor their obligations that are set out in the agreement. And force majeure would set out what exactly is the situations where this could occur. So you'll see force majeure can be defined as an act of God, as various types of disasters, and they're defined there in the contracts. Major weather events, perhaps if the force majeure clause is properly drafted, it's going to include, it won't say COVID-19, but it will talk about, some type of an epidemic or a pandemic. So if you're going to have a force majeure clause, again, it has to be in the contract. It will not be implied in the contract. The law on that is clear. The force majeure contract really is in favor of a supplier who is not able to supply his or her products or services because of this intervening event. And so the force majeure clause would likely give them the ability to postpone their delivery of their products and services as opposed to the termination of the contract. There's another legal proposition called frustration, and a contract that's frustrated becomes a nullity, and that's if neither party is able to, perform the essential terms of the contract. But if people are saying, well, we don't want to pay our supplier because he or she hasn't come, and are we obligated, and is there a force majeure clause? Again, there is no force majeure clause unless it's written in the contract. They're all written differently. You need to take the contract to your condominium lawyer for review to see if what your issues are going to be dealt with in your contract. Now here's Gene Lewis again. You're definitely getting a bill, Gene, maybe two bills. We are seeing that security is refusing to enter units to investigate noise, smoke, marijuana. No known COVID-19 issue. What is the employer and management responsibility? Well, noise, smoke, and marijuana. I'm going to suggest that the security people go to the door of those units and try to make a determination from the outside of the door whether there's undue noise or smoke or cannabis coming from the unit. I don't feel that they need to go in to the unit. So let them do their test or their observation from outside the unit. Harmony. I have a resident who is smoking weed on their balcony. We cannot see them smoking, but we can smell it, and it just makes sense that it's coming from next door. Is that enough proof? Well, I guess the proof, as they say, is in the pudding. If the smoke can be coming from nowhere but that unit, that to me is proof enough, and I would move forward, with sending these people a letter if they are causing a nuisance to other residents in the community, such as the next door neighbors. Now, Murray Johnson wrote, can we speak to the non-essential services and the force majeure clause? Well, again, we spoke about it. Every contract is going to be different. Some contracts will have a force majeure clause in them, others will not. So that's the first determination. Is there a force majeure clause in the contract? If there is, the question is, let's read it and let's see what it covers, because they're all going to be different. And it's, again, a matter of contractual interpretation. There's no one size fits all. Oh, I have a force majeure, I'm out of this contract. No, that's not the way it works. You need to review each one. All right, next one is Harlan Stavis. Harlan, how are you? Harlan, a super director in Thornhill. How does the corporation apply for the wage subsidy? That's a good question. I would go on to the Ontario government website I would type in the name of the program, and it'll probably pop up, and there you go. And you should make use of that, because everybody's going to have and is having a financial hardship, whether you're in a condo or not. Jerry DiDonato, Brian, I love your sense of humor, and thank you for expertise that benefits us all. Jerry, you're very welcome. I need to say that I'm happy to be of help, and I hope I'm helping everyone who's listening. You know, we think of COVID, we watch TV. I listen, as everybody does. It's like a baseball scores. I want to see how many people got COVID today. So, you know, and who's winning the race, and who's winning the game. And in this game, you're winning if your numbers are lower as opposed to higher. So if your score is lower, you're going to be having a better game than if your score is higher. But COVID really is a killer. It seems that for us who are, you know, thank goodness, well and not affected, it only affects us because we can't do what we normally do. We can't do our job properly. We can't go to a restaurant to eat. We can't go to the movies. We can't get together. But there are real people that are dying from this, and I was absolutely very taken yesterday when one of our wonderful presidents of a board passed away from COVID. It really, you know, hit home that this thing is a menace, and it's just not numbers. It's real people with real families living who have lost their lives. Specifically, this A1 president, great person, passed away, living in a condo, and unfortunately, his wife also got COVID. His mother, who's living in the same condo, she got COVID, and his two kids got COVID. The two kids are fine now. His mother is in intensive care, critical, and his wife seems to be getting better. So it's a real issue. But thank you very much for your kind words. Masha Koyan, could you recommend any topics or insights that property managers should and should not be communicating to condo residents in their weekly, monthly newsletters? Well, I think it's important to reiterate what the province of Ontario is putting forward as far as social distancing, as far as washing hands, as far as being careful. Those are things that I think need to be repeated in every single newsletter. Sanitize, wash, social distancing, 3 people in the elevator maximum, don't loiter in the common elements. You know, whatever the prohibitions are, just keep setting it out. The goal is to keep safe, keep your distance, and ride out this terrible storm. Next, we have Bruna. Now it's question 3 for you, Bruna, so you're getting the bill too. Security and housekeeping staff have asked for danger pay. What is your take on that? Should the board consider that, or should the contractor that hires those employees? Well, it's optional and considerate, or it's a consideration if the condominium corporation wants to add a sum of money to their own employees, people employed by the condominium corporation, as a way of thanking them for assisting in a very hard and difficult time as a frontline worker. It's not an obligation and it's not mandatory. And I think that if you have people that are working in your building as contractors, my suggestion is that the contractors, being the employers, are the ones that should be further compensating their employees for the situation. However, having said that, condominium corporations, whether the staff is an employee of the corporation or an employee of the independent contractor, if you're looking at seasonal holidays, some condominium corporations, whether or not the person is an employee or an independent contractor, would give a holiday bonus. So, I'm not saying that you shouldn't, but you may want to consider that, but I'm just saying that's not an obligation. List of essential services. Nick Basha now excludes short-term rentals. What should a corporation do in a case where the declaration allows short-term rentals? Number one, they should kill themselves. Just kidding. Short-term rentals, the government of Ontario has mandated as of April, I think the 5th, that short-term rentals can no longer be provided for anything other than quote-unquote housing. That means no tourism. Regardless of whether it's in the declaration or not, it cannot be provided. Only for housing. And for those short-term rental operators who think that they can put tourists in for housing and tell everybody that those people are going to be there for over 28 days, which is the definition for a short-term rental operator, that is a dangerous game that they're playing with people's lives. And that's something that if they're going to be caught, there should be a severe penalty or fine. And definitely the condo corporation's lawyer should be involved in that. And we are heavily involved in those type of files because we represent a number of corporations that have a significant amount of short-term rentals because of provisions that the declarants so generously put into their declarations. Harmony. Harmony's telling Bruna, we added 10% to our security contract and building cleaning / super services. Okay, so there you go. That is somebody who putting out a gratuity, increased compensation to the independent contractor on behalf of the employee of the independent contractor that works in the condo. So that's very nice. All right, we have here Ramesh, good question. How about giving access to realtors to show the property for sale or lease in condos during the COVID-19 pandemic? So in our COVID-19 frequently asked question handout, we have something there exactly on this point. The Realtor Association themselves have come out with a bulletin saying that unless something is urgent, you should not be having showings for real estate property. And that is very important because people are trying to reduce the contact of in-person contact. You can move forward with viewing properties. You can do that through the computer, through pictures, through schedules of descriptions of the layout. You don't need to be there in person. Photos and live streams, etc., can do the trick for you. And we have Jerry DiDonato, who gave me a compliment before, so we'll let you ask an extra question. Can a board make their budget information available to other boards? I don't see how, the information on what you're paying for utilities and, various other things is subject to confidentiality. I think that, you could discuss this issue, or you could share your figures, but I wouldn't share figures based on how much you're paying people. So that to me would be confidential. And then Murray Johnson here, you're not asking me a question, but you're making a suggestion, but I'm going to send you a bill now anyways, because you're at number 3. I would seek assistance from the auditor for applying for wage subsidy. Well, that's not a bad answer, Murray, but it's not up there with the other answers that you gave today. I think the Ontario government website is the best. All right. Whoops. Yeah. Okay. So I'm not going to charge you, Murray. I've changed my mind because you actually now said something smart and intelligent. You said about my story on COVID, very sad. COVID-19 is a great equalizer. This is quite true, and you're back in my good books. Nick Rowe, what are some things we should take into consideration for legal or financial preparations as this continues over the next few months? Well, I think number one, everybody's going to be suffering financially, just what's happening now. I think it's important that condo corporations make sure that if there's going to be a lack of payment of their maintenance fees, in other words, the only way that a condo corporation has really to pay its bills, you need to make sure that if those arrears are approaching 3 months, you need to lien to secure your priority over the condo corporation's money. So you need to secure the money by way of registration of a lien. However, what I would do is if there were people that actually legitimately could not pay or could not pay all of their maintenance fees, on a case-by-case basis, I would review their situation and I would try to enter into some type of payment arrangements with those specific people. However, I would never let arrears go past 3 months because the condo corporation would lose the security on its money. Having said that, I think that it would be appropriate for people to have people go into a payment plan whereby they are given 2 months maximum of leeway, and if they don't pay their first, let's say their first maintenance payment by the beginning of the 3rd month, you'd have to move forward with a lien. But you can give them a little bit of leeway. So that is from the legal point of view, and as well from the financial as well. At Concierge, we have an OHSA obligation to protect workers in our workplace. That is really a great comment. Just as you have close contact with people in the food store, the cashiers, they're putting up plexiglass. I think 100%, you got to either have a piece of tape on the floor and a sign that people cannot come within so many feet, and I guess it's 6 feet of the desk, or you have to have some type of plexiglass. Very good point. And here's Bruna assuring me that her corporation gives holiday bonuses. Well, that's excellent. Now, here is a excellent question, and this is has been sent in to me twice. Once was sent in to me, and here it is again. What is the protocol for building evacuation during a fire alarm? So here's a situation. This is a wonderful question, and this is something that I think all the managers need to address and need to think about. God forbid if this thing would happen. So here we have, let us say, a high rise of all sorts of people in the building and many floors. Everyone needs to keep social distancing, and now you have a fire alarm or an evacuation. I think this is something that needs to be thought out really carefully. How would you evacuate a building of 500 or 800 or 1,000 units for a fire alarm where you need to keep social distancing? So I don't have the answer to that, but I think the managers out there need to think about this. And if there's managers out there, I'd like you to type in a comment, because this is very, very important. Tova, that's a superb question. Thank you very much. And I also want to thank yeah, it's a great question. Yeah, Elaine also had a similar question, so really excellent. Well, no slouch here. We've got Johnson, he's back again. Fire Services says the residents should be given a copy of their responsibilities as outlined in the fire safety plan and reminded that evacuations should have distancing, don't use the handrail. Excellent comment. And I think that Fire Services, one of their mandates is education, and they are absolutely thrilled when people call them for information and education. I think you should call your fire services where your buildings are and get the information from them, and they will be of extreme assistance. Alex Humison, how are you, Alex? Good question. Are we responsible to provide constant updates on how many cases we have in the building? Of course, not disclosing who they are or where they live. So again, we're going back to my baseball analogy. The lower your score is, the better off you are. I'm going to say that you are only responsible to advise owners that a case of the COVID virus has been or is active in the building. I would say that. I don't think you need to have a running tally. There are buildings with hundreds and hundreds and hundreds of units, and I don't think it's effective to have a board, with our latest numbers. I think it's fine to advise owners that, there are COVID issues in the building. People are under quarantine. We are, set out to the owners or to the residents that all of the safety, the things that management is doing, extra cleaning, sanitization, to assist to keep people less concerned, which they of course already are, but I don't think you have to have constant updates. Here's a very good question from Debbie Pfefferman, noted property manager. Do we have a right to ask for proof of loss of employment if an owner says they cannot pay maintenance? So that's a great question, and I'm just going to say this. Maybe it's a bad analogy, but if I had a child who I wanted to send to a very high-priced private school, and I said I couldn't afford it, they'd say, Mr. Horlick, we need to see your income tax returns. Mr. Horlick, we need to see your financial statements. And the school would then have to satisfy themselves that I was a legitimate contender for a subsidy. Same as in a condo, it's not open season for rebates, deferrals, non-payments. It's a time that we need to be cognizant of the situation, of the financial issues, which are going to get way worse than they are. Try to work with people, but those asking for some type of a deferral, they need to provide absolute backup. All right, we have two more questions. Punitha, if owners have difficulty paying the common element fees because of COVID, what is the recommended response to the owner? Again, the recommended response is to perhaps in advance of the request, set out the type of information and documentation that you would require. And that's the same information and documentation you would require from every single person in the condo who asks for some type of a financial break. So it's already done, a letter. We need the following A, B, C, D, and E. That stuff has to come in. You got to check it to make sure it's legit, because unfortunately, like everything else in life, there will be people who say, I can't pay because they don't want to pay. We have one last question from Harmony. Almost one. Who should supply the PPE, the personal protective, the E is what? I can't remember. The gear to frontline staff, the corporation or the cleaning and security companies? My view is that the independent contractors, the companies that employ these people, are responsible for the equipment, the personal protective equipment. If the staff person works directly for the condo corporation, it's the condo corporation who is the employer and should be responsible for that. Nick Basha, another STR question. Not necessarily related to COVID-19, does principal residence requirement preclude a unit property manager or rental agent from handling STR on behalf of the unit owner? So under the amended City of Toronto, let's call it City of Toronto zoning bylaw, in order to do short-term rentals, one of the provisions is that the unit has to be the principal resident of the owner or of the tenant who is short-terming out the unit. And so can somebody act on behalf of the owner to get the tenant, to get the short-term renter in? I'm going to say they can, but it has to be the principal residence of the actual owner or the tenant who is doing the short-term rentals. But I will tell you this, that if this question or that type of question, leads to people who are short-term rental operators and are short-terming, many units and running ghost hotels and saying that the people in there or setting up, principal residences there, the City of Toronto and other municipalities have broad powers of investigation, including subpoenaing evidence and documentation, rights of entry into units, obtaining records from the short-term rental companies such as Airbnb, and there are very significant fines. So if anybody who's thinking of being creative in their short-term rental business, they may have a big headache on their hands. We have a few more questions here. All right. All right, we're done. We have lots of smiley faces. So ladies and gentlemen, just to reiterate, number one, if you could press the subscribe button on your screen, that will assist us, and it will assist us in getting you further information. Remember, every Wednesday at 12 o'clock noon, we have our AMA, Ask Me Anything live stream, and we'll have different lawyers talking about COVID-19 and anything related to condo. We encourage all of your questions. We'll answer them as best as we can. Again, we're all in this together. Let's all keep together. Let's all be positive. Let's do the best we can in these very difficult times. Again, look forward to our COVID-19 frequently asked questions, which are consolidated and updated and sent out every Monday. So again, thank you all for joining. I appreciate your time. Have a wonderful day, and God bless you all. Thank you.